Mr. Fulton.
My lords, I don't want to take up a disproportionate amount of time on the interest points, but if I could just start by summarising what you say was the key error on ground 5A, as put by my Lord Justice Lewis before lunch in the loss of use terms. Mm-hmm. The key error is in awarding interest twice for loss of use, including for the same time period. So once by the red arrow.
Hold on. Award interest twice, loss of use.
Including for the same time period.
Yeah.
Once by the red arrow, and again by the yellow arrow. Stevens and Bolton doesn't see how it's possible to have interest awarded twice on the same sum, including for the same time period. But I'll come back to that if necessary in reply.
Right. Can I just, at the risk of being, again, just stupid, I think, but let me try. The way that you have characterised the red arrow is as it's a prejudgment interest as damages on the principal sums, correct?
Yes.
And by the principal sums there, you in that red arrow, you mean the loss of rent.
Primarily, yes.
Well, okay. Well, plus administration costs. Is that enforcement costs? Yeah. Okay. But let's just stick to when I say rent. Let's just.
Yeah.
Everything except loss of use of the money.
Yes.
Right. Because that is the interest as damages, and that is 337,229, correct?
Yes.
And I went back to try and find out where the judge had actually ordered that. And I went back, and whether this is correct or not to go back to it, but I went back to the judgment at C20, sorry, the order at C208.
Yes.
Now, as I understand it, just looking at the order at C208, it's that this, and this was made following the reserved matters judgment. Yeah.
Yes.
In fact, it was actually made at the this is, I think, made at the consequential. Judgment.
Order.
Yeah. So, in paragraph 1, there be judgment of the claim against the second defendant in the sum of 2.2 million, being 1.7 million principal sum, which has already been paid.
Yes.
And that was basically, as I understand it, the, for want of a better expression, the loss of rent.
Less the credit.
Less the credit.
Times the chance.
Right, yeah. And then it says, plus 520014 interest.
Yes.
Now, my understanding is that that 520014 interest includes both interest as damages, the red line, plus the yellow line. It's the sum of those two, isn't it?
Yes.
So this is the first confusion, that award, the judgment includes something which is just said to be interest, but in fact we now know is interest as damages. So can we just call that damages? Is it too difficult to just call it damages?
Sure, let's call it damages.
Right, okay. So
damages for loss of use.
So at the reserved matters judgment on the up to the reserved matters judgment on the 22nd of June, what we had was something which should have been, is this right? Just a single sum for payment of damages. An order for simple payment of damages.
Or the loss of use. Yes. Yes.
Well, just damages. Yeah. Following and after that order for payment of damages, you would then ordinarily get post-judgment interest on that judgment, on that order,
Yeah.
under statute. So that should have been post-judgment interest on the damages, as I put it, which is the loss of use of rent and all that, rather less credit, plus the red line. Yes?
Yes.
Good, I'm
Yeah.
hearing a yes. But your chart, your chart here suggests that that wasn't what was actually ordered in the blue line. Because your chart says post-judgment interest on principal sums. And we know from the red line that principal sums just means the rent. Is
Yes,
that right or is that wrong?
The difference is just those two words, less credit.
Now, forget the less credit.
And
I'm not interested in the credit at the moment. We just forget the credit. Was the post-judgment interest ordered on what is in the red line, which I identify just as damages? And if not, why not?
the blue line is ignoring the credit, just the loss of use sums times the loss of chance. So the blue is just on the damages.
Just on the
Put
rent.
it that way. Yes.
Just on the rent, in fact. Because you see, if you then go to 209, it's the next paragraph in the order. The second defendant shall pay post-judgment interest on the principal sum, which I think just means on the rent, which would be consistent with your piece of paper.
Well, it's on the damages. It's on the 4.8 and the
Loss of a chance.
3.4. So
Less credit.
it does have some of those
Right.
very minor additional costs.
But the Judgements Act interest did not apply, apparently, to the damages for loss of use of money, as reflected in the red line.
No, that's right. So we say
Okay, in a sense, okay. Well, I now understand it didn't. I mean, why it didn't, I have no idea.
well, there was an argument at the reserve matters about what further interest should be awarded, which is the category of interest that Lord Justice Snowden is referring to. Barrowfen said that it should be effectively post-judgment interest, so Judgements Act interest running at 8% back to the 22nd of June on the 337 figure.
Yeah.
Stevens and Bolton said there's no reason to change the judgment date under CPR 40.8, i.e. to bring it back to that figure, because the judgment in terms of the interest is governed at the consequentials hearing. But it would be possible to award
Okay.
statutory interest on the damages using Lord Justice Snowden's terminology. What the judge did was then, we say erroneously, pluck this additional 182 figure, which was neither what Barrowfen was arguing for,
Okay.
8% Judgements Act rate on the red sum, nor what Stevens and Bolton was arguing for, which was statutory 2% interest on the red sum, but was in fact a second helping of interest on the entirety of the damages for a time including the same period.
So the original large sums before discounting were for loss of rent over the previous period.
Yes.
the red line compensates for the loss of the use of that money right up to the 22nd of June 2022.
Yes.
You say that the 182,000, although described as running from the 22nd of June 2022, in fact provides interest on the unpaid rent, which had already been the subject of the award of what you call interest as damages.
That's exactly right.
So that's just the figure. So although it says 22nd of June in your yellow line, because of the figure of 182,000, it must have been predated back before that. Is that it? It's impossible to understand this. I can't understand how you've made it all so difficult.
That is the correct time period.
Yes.
The reason the number is so big is because it's on the entire damages sum. So
it should be on the entire damages sum, shouldn't it? Shouldn't there be this? There are damages for the lost rent. There are damages for the loss of the use of money. Cut off point the date of the judgment, June. That's that. And that is a figure. Then there's the statutory interest rate on all of that amount. That's all there should be. And I can't understand why it's so difficult. Even I understand that, and I don't even do commercial law.
No, I think what you're saying is, if I've understood you correctly following that, the error you say was that yellow line does run from the 22nd, the judge ordered it to run from the 22nd of June 2022 to 24th of May 2023 on the entire judgment sum. But he shouldn't have done, because he forgets that you'd paid the principal amount of 1.7 on the 27th of September. So that was a mistake.
27th of September.
Of September 2022.
Oh, right. So you've only run from September 2022.
So is this right? You're saying that amount is statutory interest, 2% over base. Sorry, not statutory interest. It's actually, what is it? It's 2% over base.
Yeah. So we said it would be statutory interest 2% over base on the red figure.
But it's got to be on the loss of rent from the 17th of September as well, because have you paid any interest for that, or was that in paragraph 1?
That's the red arrow. That's the interest as damages. That's the interest on the loss of use of the rent. Albeit that under Sempra Metals, that is a substantive claim.
Right. I mean, all in your case, all there was outstanding was interest. Now I'm going to start differently. There was outstanding interest on the interest as damages. That hadn't been dealt with. And then going forward from the 22nd of June, you, in one way or another, it was appropriate to award interest on everything that was due, which would be that amount and also the capital sum, so to speak, compensating for the loss of rent. Normally you would do that by post-judgment interest, and post-judgment interest was indeed awarded.
Yes, that's good.
And then one wonders what else the award is for.
Yes, exactly. So Barrowfen has been made whole in respect of the loss of use by virtue of the red and the blue arrows, and there's no call for a further award of interest directly on the loss of use, because they have interest as damages up to the judgment. From the judgment they have post-judgment interest, and then they are paid in respect of that on the 27th of September 2022.
But just pause there.
That's it.
But just pause there. They haven't had post-judgment interest on the red line.
Exactly. That's the only thing that's missing. Everything should have been sorted vis-a-vis the rent losses, and all that left was the damages for loss of the use. But from what you're saying now, it looks as if he forgot, as my lord said, that they'd already paid the money for the loss of rent. And when they were calculating the interest on the loss of use of the money, he accidentally calculated it on an amount that included the loss of rent as well. Is that it?
Yes, and it's, taking my Lord Justice Snowden's point, that is the outstanding possible interest award, but it's only for £15,000 odd, because it's the interest on the damages in the red.
And is it accepted that that should have been ordered?
Yes, we accept that the 15,044 figure.
So the
We
15.
accept that's outstanding.
So that should have been added to the 36,000 agreed.
Yes.
So what you object to is the yellow arrow,
Yes.
and you object to the yellow arrow because it's calculated on the whole sum, forgetting that you'd in fact paid the 1.7 million on the 27th of September 2022. That's one mistake.
One error. Yes.
Is that 5A or 5B? I've forgotten.
Well, that falls outside either, because it's conceded by
Okay.
Barrowfen.
Right. Okay. So that's okay. So right. Okay. Now I can't remember what the problems with 5A and 5B were.
So I'd say effectively there's three problems. So one is the interest is being awarded twice on the damages, adopting my Lord Justice Snowden's terminology. The second problem is that there's the yellow pre-judgment interest running at the same time as post-judgment interest on the damages, and that's the blue arrow. And the third problem is that Stevens and Bolton have paid the sums in respect of the damages, so that from the 27th of September 2022, there should be nothing running on the damages.
I understand the third, but that's conceded. Of those 3 points, is that right?
Yes.
Third is conceded. The second one I understand. What was the first one again?
So the first one is the point that interest is being awarded twice on the damages, because the 182 figure is calculated as interest on the damages, i.e. the 4 million odd sum.
Can I just try it is another way? It's right. The yellow line did indeed have to run on to the 24th of May 2023.
Yes.
There's no problem with that. The problem is that all that hadn't hitherto been provided for in one way or another was interest on the interest as damages.
Yes.
So it was indeed right to have some kind of award dealing with interest on interest as damages up to the 24th of May 2023, but that was all that was left.
Yes.
Only the 15,000 odd, yes.
And that's the only mistake that hasn't been conceded, as I understand it. Or has it been conceded?
No, the only thing that's been conceded is that allowance should be made for the 1.705 million paid by Stevens and Bolton, i.e. the third error that I referred to. What has not been conceded is this ground 5A, was it on the wrong base figure? And then if Stevens and Bolton is wrong about that, the 5B, if one is looking at the damages as the base figure, whether credit has to be given for the RDS in calculating interest. That's the 5B, which I'll come on to now, unless there's any other questions. So I'll just deal very briefly then with the 5B. And if I could just show you, please, the email exchange that I referred to earlier. So this is supplemental bundle tab 38388. And this just sets out the respective parties' understanding of the basis for the additional interest award. And essentially all I take from this is that on S390...
Sorry, can you just wait till we get there?
Sorry.
My file for one exploded
Is it,
yesterday.
just give us the page reference again, please.
S390. So this is a characteristically polite and helpful email from Mr. Mathewson, where he says at 1A, Barrowfen considers that the additional interest award was awarded as interest as damages. I think we're just calling that damages. And then my response at the top of S389, 1B, says, we don't record this necessarily as having been awarded as interest as damages, let's just call it damages. And in particular, because the award was given immediately after Mr. Stewart highlighted that the judge had power to award Section 35A interest on the outstanding amount. Now that's significant because, as we saw just before lunch in looking at the reserved matters judgment, Mr. David, on behalf of Barrowfen, accepted that if this additional interest award were statutory interest under Section 35A, credit would have to be given for benefits flowing from the relevant breach. And that's at the reserved matters judgment, page C605. And so if it's statutory interest, we are home and dry on ground 5B. Of course, the judge was non-specific in relation to the basis. He just referred to pre-judgment interest. So I need to address the possibility that this is interest as damages.
Was this a draft order that was agreed by the parties?
There was. That was agreed by virtue of that email exchange.
Yes. And
there was a compromise between myself and Mr. Mathewson where we just referred to the sum as interest because we had these differing...
This is the one we've been looking at.
Exactly.
The T2A, which is why I find it really awkward to look at because it wasn't clear.
But what is clear is that the judge thought this was pre-judgment interest. He says that in the agreed transcript we looked at.
All I'd say for the future, for lessons learned, in case you get another judge who doesn't understand commercial law, English is a very simple language. Use words that relate to the concept. To put in interest is bound to send people off on a wrong thing. It was damages because you hadn't had the use. And you're having all these email exchanges and agreed orders, and you're not explaining to the judge, leave alone to us, what you actually mean. You toss in the words principal sum, what does that mean? Yesterday to speculation. It's just so much more helpful if words are used precisely to describe a specific context and there can be no misunderstanding. Anyway, there we are. Such is life. On we go. Where are we now?
Lord, thank you. I'm very grateful for that indication. We will, of course, bear that in mind. I'd just like to rest on what we say in relation to interest as damages on our skeleton. This is at C66, 44B. And we say that there are first instance cases in relation to Force India which show that under interest as damages, one must give credit for benefits received. And we rely also by an analogy with the tax cases cited in the McGregor extracts there. If there are points on those authorities taken orally, then I will take those in reply.
No further questions.
Thank you very much. Mr. Kramer.
My Lord, it's a speculation on my part, but I think it might be useful if we kill interest now, and so I'm going to ask Mr. now it's so clear to you all, I'm going to ask Mr. Mathewson to deal with interest first and get that out of the
Poor
way.
Mr. Mathewson is reconciled to dealing with it now. It's...
My Lords, so I'm going to address you on the interest issues.
Yep.
And to try and, if I can, simplify and cut through the issues, what I understand to be the key dividing line between the parties is the date until which the interest as damages should run.
Not interest as damages, that doesn't help me at all, because we know what date the interest until damages should run, up until the date of the judgment. So that's sorted.
The date, I say the relevant judgment date is the 24th of May 2023. And that's what the judge awarded. That's how he gets to the 520,000 figure.
Is that okay?
So I say the red and the yellow is all interest as damages. And it's one continuous line. The diagram I say isn't that helpful because it doesn't show that this is one continuous award of damages for the loss of the use of the money, if we put it in those terms, through to the relevant judgment date, which is the 24th of May 2023.
Yeah, so in fact it's the relevant order. I mean, the order we were looking at C28, C09 is the first actual order for payment, isn't it?
Yes. Correct.
So you're saying that
Yes.
up until, you're saying, is this right? You say that up until the order we're looking at on the 24th of May 2023, there is there's nothing but damages payable.
Yes. So you have to give credit. That's the concession we've made for the 1.7 million that was dealt with in the reserved matters judgment in June 2022 and paid in September 2022. So we accept that the 1.7 million comes out of the calculation and it divides off into the blue line. That's the blue line, the 1.7 million. The rest of it, the rest of the damages, continues through in the red line and then a slightly smaller yellow line through to the judgment date, which is May 2023.
So can we suppose there's some unpaid rent in the very first month back in 2016. Now you're entitled to be compensated for the fact you didn't receive the rent. And you're entitled to be compensated in one way or another for the fact that you're having to wait from 2016 to whenever to be paid the rent. Now on the face of it, the red line calculation should cover that up to June 2022.
Yes.
So if we take that very first non-payment of rent, we add on some more to take account of the fact you're being kept out of it for 6 years. Now come June 2022, you start being paid statutory interest on that unpaid rent because it's part of the calculation of the principal sum outstanding.
That's not quite right, my lord. The rent losses up to June 2022 are about 4 million once you take off the loss of a chance percentage. So there's 4 million of funds of which Barrowfen is without, and it's losing the use of that money. What happens in June 2022 is that there is the first judgment for 1.7 million, which is paid in September. So Barrowfen is no longer out of 1.7 million of its 4 million of lost money, but it still has the loss of the use of funds of 2.3 million.
Well, it hasn't, has it? Take the very first payment of rent. You're not actually entitled to payment for the whole of that. You're entitled to 60% or whatever of it. But leave that out of it for a moment. So if one ignores the deduction, come June 2022, you get judgment for all the rent that was unpaid.
Well, we don't, my lord, because we only get judgment less the credit. So we have 4 million of unpaid rent. And because Mr. Justice Leech says you have to deduct from that the capital value increase, and that's Barrowfen's appeal, we only get a judgment for 1.7 million. But we've suffered the loss of use of 4 million of funds.
No, not if you weren't entitled to it. I don't see that. How can you be entitled to a loss of use of 4 million funds when you're only entitled to recover 1.7 million? I just don't follow it.
Well, the judge below found that, and there's no appeal against that.
Can we just talk through that again then? So I've taken one particular payment of rent, but up to March 2021, you'd suffered all these shortfalls in rent. But on the judge's assumption, come March 2021, you end up with a better product. Therefore, it's right to take off a sum at that stage. So your shortfall at that stage is all these unpaid rents less the capital deduction.
That's
well,
what the judge said. You may not agree with it, but that's what the judge said.
He doesn't say that in terms of interest. When we come to interest, what he says is that Barrowfen has still suffered the loss of the use of the funds, because interest is about compensating the loss of use of money.
But come the point
I'll
at
show
which
you the part in the reserve matters
come
judgment.
the point at which you've got the better building, on the face of it, you have to net the one against the other. So what you're being kept out of from that stage is not all the rents for relevant purposes, it's the net sum that's due to you.
Well, my lord, if perhaps to answer that, if you could turn to tab 20 of the core bundle. Page 608. And this was the first dispute about interest that took place at the consequential hearing. And the first argument was about whether interest as damages for loss of use of the money, should go up to the 22nd of June 2022, or whether it should stop when the revised development scheme was completed.
And the judge obviously lets it run on to
Yes.
June 2022.
And so it's that judgment at page 608, the judge decides, and there's no appeal against it, that the interest continues to run on, because Barrowfen continues to suffer the loss of the use of funds. And so it's the third and the fourth paragraph.
Damages run. Interest as damages.
Interest as damages, yes.
Damages runs on. We're looking
Damages,
at damages.
yes, damages. And so the third and fourth paragraphs, in this case, the function of the award of damages, so that's the rest of the damages apart from the one we're looking at now, is to compensate Barrowfen for the delay in the development of the Tooting property. The role of damages is compensation for the loss in not developing earlier. The way in which I compensated Barrowfen was to award the income stream between September 2016 and the date on which Barrowfen would have completed the development and was able to let the property. The function of interest is different, and this is interest as damages for loss of use of the money. We're using different terms, but that's the point here. The function of interest is different. It is to compensate Barrowfen for being kept out of the relevant funds until final judgment. Barrowfen did not receive payment until September 2022, when Stevens and Bolton paid the money. I agree that once the revised development scheme was completed, Barrowfen had an asset, but its entitlement to interest did not end on that date. That entitlement only ended when the money was paid in September 22. I therefore accept Ms. Hilliard's submission. Barrowfen was made whole in March 21 in the sense that it suffered no further damage, but not interest. I award interest as damages from March 21 to June 22. So, in my answer to your Lord's question, no, Barrowfen was not made whole in my submission in March 21.
But damages on what, though? That's the problem. Interest, loss of money on
the
what?
use of money that it...
No, I understand that, but on what, 1.7 or 4.2?
So, up to June 2022, it's on the entire amount. It's on the 4 million. It's all the rental losses.
Without the credit.
Without the credit.
Why, though?
But that's not the subject for the appeal.
It's not the subject of an appeal.
Whatever we might think about it, it's not the subject of an appeal.
Come post the 22nd of June 2022, what were you being kept out of?
Yeah.
And so, post the 22nd of June 2022, we are no longer kept out of the 1.7 million because we accept, and that's our concession, that a judgment was given for 1.7 million and that was paid. We are still kept out.
Even though there was no order. There's no order reflecting it at that stage. There was no order made on the 22nd of June.
There was,
but the blue line, as we see it now, compensated you for the delay between the 22nd of June and the 27th of September in relation to the 1.7 million.
Yes, there was no order until later, but the parties agreed that because in relation to the 1.7 million, the written judgment of June 2022, because it actually stated a specific sum that had to be paid, it said, you know, I award damages for 1.7
Anyway,
million.
we were looking at the amount, the money that you've been kept out of, and you weren't kept out of the 1.7 million because it had in fact been paid, whatever the rights and wrongs of it. So what else were you kept out of?
So the rest of it, so one has to accept the judge's logic that up until June 2022, Barrowfen is being kept out of the use of 4 million of funds.
So you're saying that you were kept out of the 2.3 million, that's the actual figure that
And
you were
so
kept out of.
after June 2022, Barrowfen continues to be kept out of the 2.3 million, the 4 million minus the 1.7 million. It still doesn't have the use of those funds that in the hypothetical non-breach world it could have reinvested and made a return on.
Even though you weren't entitled to them and the judges never ruled that you should have them after, was it June 2022?
Well, the judge does award these to us. I'm going to show them. He does give us.
But why stop at May 2023? I mean, why not now?
The short answer to that is that was the date. That was the judgment date. And
but why should that matter? Because if full payment of all the damages due to you doesn't stop you being kept out of your money, I mean, why stop ever?
Well, my lord, I mean, in this particular appeal, one doesn't need to answer that because we didn't claim it, it therefore wasn't argued. But, I mean, if that had been sought by Barrowfen, I mean, there are potential arguments that no doubt could and would have been raised. And, for example, Barrowfen should have sold the property and, realised the cash and therefore it was no longer out of the funds. So it no longer suffered the loss of use of money. Those kinds of arguments no doubt would have been explored if Barrowfen had continued to claim into the future. The fact of the matter is it didn't. It only claimed up to the judgment date, and that's what the judge awarded.
So, just trying to understand, the award of the statutory interest, you say, is not on the totality of what you lost, because it takes into account the value of the building.
So, this by the statutory interest, you mean the post-judgment
interest.
Act interest? Yes, that is only on. Well, it is on the judgment debt. I mean, that is what.
And that would the reason why that doesn't correspond to the totality of the rents is because of the deduction in respect to the value of the building.
Yes.
So what we're really arguing about is, in effect, whether you should have interest as damages running on the value of the building.
Yes, and that is what the judge awarded. And I think my learned friend, his primary ground, his ground 5A, says, well, the judge made a mistake. He didn't mean to award that. And I say, yes, he did. That's my short answer.
And when you say the judge awarded, we're talking about the period from the 22nd of June onwards, are we?
Yes.
Because the only thing I can see at page 608 at the moment is what you've shown us, which is until the 22nd of June. So are you saying it's implicit in the logic, or are you saying I've missed words on the page?
I'm saying I haven't shown you the next page yet.
Ah, right, okay. Well, you don't give us a chance, I'll give you that.
So if you look over the page, there is then another point about compound or simple interest. And then at point 3, the judge addresses the period from the 22nd of June 2022 through to the 24th of May 2023. And unfortunately, there's not much reasoning here, and it's because, as my learned friend adverted to, it's the nature of how this note was produced. There's no transcript, and we've agreed in a note what we were able to agree. But what the judge concludes is, I provisionally order 520,000 in pre-judgment interest until the 24th of May 2023. And so that's on page 609 of the bundle.
And it stops there then, you can't claim any more now, can you?
No,
Even you can't claim any more, can you, after that?
not unless we succeed on our appeal.
Right. Well, no, the appeal is different, yes. And you say we're left with that date. It seems an odd date to choose, but you say you've got it, so why should you give it back?
I've got it. Well, my lord, it's the judgment date. I mean, that is why it was chosen.
So, I don't know if this is the appropriate time to ask this question, but if you look at this coloured chart again, I think you said at the start of your submissions that what's really unhelpful about it is that the red and the yellow line aren't continuous. Just so I've understood the point, the red line is pre-judgment interest as damages. The judge calls that pre-judgment interest, but it's pre-judgment interest as damages.
Yes, my lord.
On the sums received, sorry, not received by way of rent. Is that correct?
Yes.
What, without a deduction for the capital value of the building?
Yes, correct.
Okay, and that takes us up to the 22nd of June.
Yes.
And what the judge is doing from the 22nd of June 2002 is to continue to award interest as damages.
Yes.
But he's now awarding it on which sum?
Well, he's to get to the 520 continues to award it on the entire 4 million, the entire lost rents, and that's my concession. I concede that was too much. There should have been the 1.7 million.
So it should be on 4 million brackets less 1.7.
Yes, ma'am.
Effectively.
Yes. And it is my submission that what the judge was doing there was ordering interest as damages for lost use of the money all the way up to May 2023. I think my learned friend disputes that. There's a difference of characterisation of this.
I follow the logic of your case, and you say, well, if he's going to award interest on as damages up to the 22nd of June,
yeah,
why stop there? Why not run it through to the judgment date, which is effectively what he did?
My lord, the reason it's a little messy the way it came about is one of the points my learned friend makes in Skeleton argument, and I accept, is that the way Barrowfen initially put its case, it said, well, primarily we're going to claim interest as damages, damages for loss of use of the money up to June 2022, and after that, from June 2022, we initially said we want post-judgment interest at the Judgment Act rate. Now, the response we got to that from Stevens and Bolton was, no, you can't have post-judgment interest from June 2022 on your interest as damages claim because there's no judgment yet. They said there's no judgment on that part of the loss because it wasn't quantified by the judge in the reserved matters judgment, and it wasn't. I mean, the judge decided that in principle we could have our interest as damages, and he decided the rate was 2% over base, but he did not decide, and this is paragraph 136, from when until when, compound, simple, things like that. So there was no judgment debt until May 2023.
But, sorry, just maybe I missed it in the course of the exchanges. If the yellow line reflects interest by way of damages on the entire principal sums, i.e. the non-payment of rent, without reduction for capital, because the judge, that's what the judge said, and you say there's no appeal. You accept that you should give credit for the 1.7 received in September 27th September 2002. To that extent, it should be reduced. Why are you entitled to interest as damages on the non-receipt of rent, as well as getting post-judgment interest on those self-same sums as represented by the blue arrow?
My lord, we don't get post-interest judgment as damages on that. So we only get post-judgment interest on the 1.7 million. We're not getting post-judgment interest on the rest of it.
All right. To the Sorry, so that the yellow line is does not include interest as damages on the 1.7. I thought it did.
Well, it shouldn't. It does, but that's the concession that I've made.
In effect, this is, as adjusted to take account of the 1.7, it really is interest on the amount of the deduction that was made for the value of the building.
Yes.
Just, and I follow how you put it. Well, if the judge is going to allow it to run on past the March 2021, well, why stop at June 2022? Just going back to page 608, which you showed us a moment ago. There, the judge ends up by saying the entitlement only ended when the money was paid on the 27th of September 2022. So why did he say that if he was then going to think that you should go on getting interest as damages beyond that date?
Well, my lord, I think that was because of the rather piecemeal way in which it arose. And as I said, Barrowfen started, I accept, by only claiming it up till June 2022. And then it was only during the course of oral argument, sort of when we came on to the next period, when Stevens and Bolton submitted, well, the judgment date is May 2023. My learned senior at that point sort of said, well, why doesn't judgment interest as damages continue to May 2023 then? And so my explanation would be it's a matter of chronology. The judge, when we came to the third point, realised it should extend through to May 2023.
Was this judgment given in stages? Is this a note of there was a judgment on this and then a judgment on that and then
Exactly, my lord. It was three discrete points argued and then ruled on separately.
Just out of interest, where are the calculations that underpin these numbers?
They are in RPC's letter, which is
tab S29 on page S309, and the 337 is S34314.
Okay, so it's the numbers in the blue. It's the numbers in blue. Sorry.
So it's page 314 of the supplemental.
I'm really after the calculation that underpins the yellow line, the 182785, or at least the 337229.
So the figure is on page 314 of the supplemental bundle, paragraph 3, and then in row 5 of that table, it's the uncompounded figure.
Hang on. My exploding bundle. Just give me a second. So 314. 304. Which
page 314 of the supplemental bundle.
Yeah.
And that is a letter from RPC, so Stevens and Bolton solicitors. They set out calculations which were agreed, setting out how the interest as damages claim, what it came to, depending which date it went to, and whether it was uncompounded or compounded. So the judge ruled that it was uncompounded, so you're in the left of the two figures columns, and then in my submission he ruled that we were in row 5 because it went through to the 25th of May 2023. And again, the error being no credit was given for the 1.7 million, it's actually 442.
So to recap then, the only thing we are deciding is whether or not, or are we deciding whether it is right to include damages, losses of money on the whole amount, excluding 1.7, but including the value of the building which hadn't been deducted of that.
Well, I don't think that squarely raises on my learned friend's appeal. I mean, he says the judge made a mistake. He says the judge just got the figures wrong. He was meant to order interest on interest and adopted the wrong figure. The judge didn't adopt the wrong figure. In my submission, he intentionally adopted that figure because it was the agreed figure for interest as damages through to May 2023.
Right, so you say that's what he did, and if that's what he did, that's the end of it.
Yes, and then there's the credit point, which was ground 5B. That's the only point of principle. And just very briefly, I know Mr. Kramer's keen to address you on the other points. In response to sort of ground 5B, which is the credit, I say Stevens and Bolton doesn't appeal the judge's decision on page 608, I think it was, the first page of tab 20, which decides that interest as damages runs on the gross income losses, ignoring the credit. And so it's inconsistent for it to now say the credit is somehow relevant when one's looking forward to May 2023. Secondly, I say the judge was right as a matter of principle, because Barrowfen still didn't have the cash, it still didn't have the money, it lost the use of the money. And thirdly, I say that Stevens and Bolton doesn't come up with any principled reason why, as is inherent in the nature of its case, that entitlement to interest should stop on the 22nd of June 2022. The only two options before the court are, does it stop on the 22nd of June 2022 or in May 2023? And I say it stops in May 2023, which is the judgment date, which is when, and it's the judgment date because Stevens and Bolton conceded it was at the time, and because that's when the actual amount, the liability, was determined and crystallised. And so that's why I say the judge got it right. And my lords, you'll be aware we say that if we succeed, the total amount of damages come up, and we would claim then damages through to the date of the Court of Appeal judgment on the outstanding 2.3 million that remains unpaid. I don't want to detain you further with that at this stage because I know Mr. Kramer's keen to speak.
So sorry, I hadn't really taken on board the last point. So you say that if you're right, you're entitled to damages up to now.
Not in response to my learned friend's appeal. So this is a completely separate point. I've dealt with my learned friend's appeal. The final point I sought to make was that if Barrowfen's main appeal is correct, so if Mr. Kramer persuades you about Barrowfen's appeal,
yes,
and we haven't been awarded the correct judgment.
Well, that's different though then, yes.
Yeah.
That's,
It's a different
that's
point.
just the consequences of you winning your appeal. That's nothing to do with this.
So this doesn't need to go in the judgment. It would be something to be addressed at the
Yes,
consequential stage.
my lord, it's different, and I only raised it just to draw your attention to the fact there is potentially a separate interest point.
Yeah.
My lord, those are my submissions.
Thank you very much. Mr. Kramer.
Thank you, my lord. Of course, if we win on our appeal, none of that matters. just a little thing to hang
So
out there.
tempting.
Yes. My lord, to avoid running my time out without getting to it, I'm going, if I may, I'm going to deal with the cross appeal first, and therefore the loss of chance
Oh, yes.
matters. I'm going to start with supplemental bundle tab 24, which I find quite helpful. It's not to have been in colour, but it was once. Page 289 of supplemental bundle. You should have a diagram there. So what that reminds us are the findings of the judge. I think this was handed up by the Barrowfen legal team at trial.
When you say at trial,
Probably the reserve matters.
it
Yeah,
would have
I
to be
think,
later
yeah,
on
yeah,
when
exactly.
you've got the percentages to put in.
They were able to foresee. No, it wasn't that. So you'll see the first probability split is at the top, and on the company claims, if the wrongdoing embodied by those claims hadn't taken place, there's a 60% chance of going down the left-hand fork with the amended original scheme commencing in 2015. You see 60% at the bottom. And then you have a 40% chance of that not happening. That 40% is not just left hanging in the air, of course, as something that's never discussed again. That 40% is then considered because there's another chance for control to be saved, and that's through the administration claims. And it's found within that 40% that there's an 80% chance that, but for that wrongdoing, the amended original scheme would have commenced in 2016, and you see at the bottom, therefore, it's 40% times 80%, which is 32%, and that number appears in the judgment as well. And then you have the 20% of the 40% on the right. The word RDS is controversial because the whole of the appeal on this now appears to be whether that word should go in that box or whether you should replace that word with property explodes in puff of smoke and has no value thenceforth. or as Mr. Stewart put it, anything could have happened. There could have been another scheme, might have been sold, etc. But you see at the bottom that leads to an 8%, and the 60 plus the 32 plus the 8 make 100. And then lower down, your loss is 60 times 60% of 4.8, 32% of 3.5, and you could have added in 8% times 0, because there's no loss awarded for the 8%, and that's clear on the maths. So the essence of the dispute is, where do you put the 2.5 million credit if you're giving it, that being the difference in developer value at 2021. The judge put it in the left-hand column, so the 60% column, and in the middle column, but not in the right-hand column. And the claimants say that he was right to do so, because in the 8% column, that there is a 0 rather than 2.5 million. There's a 0 developer's profit difference between the breach and non-breach positions, because the same thing happens in both. So you'd be comparing the RDS developer's profit of 12.5 with the RDS developer's profit of 12.5, and you would have 0. So it's not that you're not crediting the Tooting development. I can see it on the high street. It's certainly there. You are. It's just that in 8% of the chance, you're also offsetting it by the very same thing, and therefore there's 0% loss.
I assume you're coming to this, in which case just tell me to wait. But a key point does seem to be, do you get the revised development scheme in the 8%
Yes.
position?
Exactly. So let's look at that. If we start with, I'm just going to show you a few documents to that point. First of all, if we go to tab 22 of that same bundle, supplemental bundle, and then we go to 237. This is a transcript of the argument in May 22, so reserved matters hearing.
I assume the fact that you haven't dived into the judgment straight away to answer my Lord's question suggests that there isn't actually an answer in the judgment.
No, that's wrong, there is.
Why are we going
Just
to
belt embracing it, because it's the whole point of the appeal. So you'll see, my lord, if you just give me a few. I haven't got many documents. If you see 192.19.
So I'm on S237.
Yes. So sorry, I say 192.
Oh, you
I mean
mean the page numbers
internal.
in the middle, yeah.
Sorry, there were many
so
page
sorry.
numbers.
Yeah.
Internal page number.
So what stage are we at? This is closing submissions, is it?
I think that's right. May 11. Yeah.
Submission in relation to
It's
the
the-
judgment hearing.
Yes. I don't know if it's open or closing or just submission.
I
Closing.
think it's closing.
Yes. I think that's right. Closing.
At the end of the trial, before the reserved.
At the end of the reserved matters.
At the end of the
hearing.
reserved matters hearing.
Yes.
There was short evidence given in relation to that,
Yeah,
and then
okay.
there was speeches in relation.
There was experts and a bit of factual. My lord, the point is that it's binary, and it's binary like in the other cases. The binary position being, if you don't get the better thing that you lost the chance of, you still get the thing that you actually got. That's the argument between us. Does the 8% mean we would have still got the RDS? And the judge is realising there's really only two outcomes. Either it all goes well and they get the original scheme, or Girish refuses advice, continues to fight, and the company goes into administration.
Hang on, the judge isn't finding anything. The judge is just trying to understand what's
Yes.
being said to him.
That's right. That's right, my lord. And then if we go to the main judgment, which is at core bundle...
Hang on, just pausing
Yes.
there. That doesn't seem to deal with our 8%, does it? There are two outcomes. One, he accepts the advice and the original scheme goes ahead. Second, he refuses the advice, continues to fight, and the company goes into administration. But the company goes into administration is the...
8%.
It's not the 8%, is it?
No.
Yes. and then if you go over the page, because Mr. Dawid says, well, hang on, there's 3 outcomes, my lord.
Yeah.
There's the 60%, and then there's the 30%, and in both of those, the scheme goes ahead. At different times, but both avoid administration. That's the whole point of them. You either avoid administration earlier, you get control earlier, company claims, or you get control later but still avoid administration, still get the original scheme. But if you go into administration, Waitrose pulls out, etc. So, and the judge says yes. So that's the 8% of no loss, and the judge says no loss. Then if you look at the main judgment, so
hang on, does he say any more about what would happen on the 8%?
no, just no loss.
But that sounds as though he's just repeating what's been said to him. So,
Well, we'll see.
yeah. Well, I suppose there is no loss.
I mean, he doesn't have to do any quantification,
No.
but we'll see the judgments. I just wanted to, I think it's explanatory because it's the closest to that diagram. But if we then go back to the main judgment, which we want to go to, I think, let's start with, so it'll be in the second volume for Justice Snowden. If we
So
start,
what you've just shown us was
Yes.
about what was said at the...
yes, I'm going back in
And you're
time,
now going
yes,
back
yeah.
2 years earlier via the TARDIS to what happened.
I'm
Okay.
going to a different bundle, yes. That's
So what I'm about to look at
Is
can't
the-
have any relationship to what we've just
No,
read.
we're going to look at both
Okay.
judgments. I was just trying to use the second bundle.
All right. No, it's...
It was no cleverer than that.
Right.
My lord, if we go to page 477, so we see here paragraph 678 to 681, and contrary to what Mr. Stewart said a couple of times, you'll see, so the primary case, this is the 60% case. The 60% is multiplied in 679 by the net rents, the administration costs, and the revised scheme costs, because those are costs that would have been avoided. My learned friend says, oh, you get 100% of the additional costs of the revised scheme. That doesn't make sense. That's not what the judge did. The judge deliberately only awarded the avoided revised scheme costs in the 60% and the 32%. So that's this page and the next page. Not in the 8%. Why? Because the revised scheme would have happened. So my learned friend is right to say it would have been inconsistent at his paragraph 25 to award just the flat-out revised scheme costs. But he's wrong. The judge didn't do that, as we said in our paragraph 74. Now, there's no separate heading of the 8% case. Did the judge forget that there's an 8% case where anything could have happened, a different development? We say, of course not. And if we go forward to page 487, we see paragraph 709. The first chance is taking control, and the second chance is avoiding administration. It follows that the flip side is if you fail in your second chance, that's the 8% residual percentage, you don't avoid administration. And so you're right back into what actually happened, which is there was an administration and then control had to be rested later, and Waitrose pulled out and costs went up by 15%. It was then necessary to revise the scheme, and it became a different scheme. It took out students. The viability meant that they had to argue for an extra floor, all sorts of things. So once it's clear, and I'll show you the reserved matters judgment as well, but once it's clear that the flip side of the 32%, which is the 80 of the 40, is you don't avoid administration, i.e. there's an 8% chance that I think what Mr. Stewart had been arguing all along at trial would have happened, which is their advising and doing their duties wouldn't have made a difference, then you're into didn't make a difference. The administration happens, no loss. The alternative is that the judge forgot about the 8%, and what he should have done is hear evidence about what would have happened, but I don't even know what that would look like, because once you're in the administration, we know what happened. So I can well see why that just doesn't even arise. Now, my lord, we can look also at the reserved matters judgment, which is going to be in your second bundle. Sorry, your second core bundle. We go to...
Sorry, so
Yes.
just to be clear where I am
Yes.
so far,
Yeah.
you say, okay, if they hadn't been negligent in relation to the company claims, there's a 60% chance that you'd have got the amended original scheme at an early date, finishing in September 2016. If they had then not been negligent in relation to the administration, avoiding administration that is, you would have a 80% of 40% chance of ending up with the amended original scheme completing in 2017.
Lord.
Those are the two matters for which you are entitled to claim damages.
Yes.
And you do so by way of the addition of cumulatively the two losses of chance.
Yes, 60 and 32.
Right. The remaining possibility
Yes.
is that even if they'd have been negligent in those respects, the company
Would have still gone into
still gone to administration.
And would still have done the scheme, the
Still
revised
done the
scheme.
scheme.
Yes, that followed when it was got out of administration. Stevens and
But that-
Bolton
but
were
that
off
is
they were spent by then. There's no more wrongdoing. In
But that's
fact, they were
So that's a
disinstructed.
benefit that your clients have, come what may.
Yes, so we don't have to credit it to reduce our damages because we would have had it anyway in that 8% world. So in the 8% world, there's no loss and no gain. We're no better off and no worse off.
If none of this dreadful thing had happened, you'd have had a much better building in Tooting. Or there's an 8% chance you'd have had this much better building in Tooting. Is that it?
Do you mean the 8%? The
No.
8%.
There's an 8%
Depends what you mean
chance.
by none of this would have happened.
Yes. If none of this dreadful thing about the share register being tampered with and the resignation letter
We'd have had,
and the negligent advice and everything,
Yes.
if the world had been perfect
yes.
and everyone was happy, there's an 8% chance you'd have ended up with a revised scheme anyway. The building that's standing there would have been the one you'd have got anyway.
Vis-a-vis Stevens and Bolton's wrongdoing,
Yeah.
definitely, yes.
Okay, we'll stick to them then, yeah.
Yes.
Because you say there's no reason to think that things would have gone any differently from how they did go.
Nor has any been raised, because once you're in administration, well, where's the evidence that anything else, they didn't plead anything else was happening. They didn't plead a deduction. Well, you never would have got the revised scheme in that situation.
But it
There's
is
no
as
evidence.
simple as that. If they hadn't been negligent, there's an 8% chance that what we see on Tooting High Street is what is on Tooting High
Yes,
Street.
no loss,
That's it.
You
but
just,
no gain.
so you
And
just
no
say,
gain.
yeah. So you just say it doesn't result from the negligence, therefore they can't take it into account.
No gain. It's not a credit to. So then you get into mathematics.
Well, hang on a moment, that's
Yeah.
quite important though, actually, because
Yes.
does it result, is that what you're saying conceptually, that because there's an 8% chance it would be there in its current form, and you
Yes.
said no loss, no gain, but is that the right question?
Yes.
It's not causation, is it? I mean,
It's not. There's no law. This is factual causation. But for the wrong, put me in the position I would have been in. You're already in that position.
yes.
If you look at our skeleton, not a skeleton. If you look at our skeleton, page 6, paragraph 22.
So your skeleton,
The second skeleton. No.
Yes, sorry. It's headed Respondents skeleton on behalf of Snowden. My lord, there's a diagram at paragraph 22.
Sorry, I'm just trying to get your screen. Under the heading, the implications of these findings.
Exactly, my lord, yes. And I hadn't quite finished with the findings, so I'm still going to show you the reserved matters judgment. But you just see there, those are your, in row form, it's the 3 columns of that diagram. And I'm comparing the non-breach position with the breach or actual position. And I don't think that can be seriously disputed on those findings. You've got a different position, so the credit to be applied when you get to the 3rd row is 0, because there's just no difference between the 2 positions. Now, all I'm doing is repeating myself with the diagram, but I often find they help. Now, see, what does that do to the mathematics? Well, you could take 60% of all of those rental losses and then deduct the credit. Sorry, yeah, then deduct the credit. That's what we say should happen. Sorry, 6% of the losses with the credit, all in.
You say the reverse.
Yes,
actually,
brackets,
of what you just
bracketed,
said, yeah.
yes, bracketed, all together. Do 60% of that, and you do 32% of the different number, and you don't do anything for the 3rd row, that's 0%. But
So taking the first possibility,
Yes.
you say there's a 60% chance that you have lost the difference between the rent and the better development.
Yes. And you just do 2 rows and that's all your calculations. If you want to do the maths differently and you want to say, well, in the actual world, I certainly have a Tooting development, I'm just going to credit that, then I have to have a row which also credits 8% of it on the other side, and it's the same maths.
Yeah, well, I was just going to say, and you'll see that there's an obvious answer, and this is just as wrong as most of the other questions I've asked in the last 2 days. But the fact of the matter is,
That would be speculation.
you've lost 60% of the rents, and we know that, that's fine. But you've got a very shiny building. There's an 8%, you would have a very shiny building whatever happened, even if there'd been no breach by S&D. So why are you reducing the shiny building, the value of the credit, by 40%, taking 60% of it, when in fact, on any analysis, there's a 92% chance it's come there because of the breach, if you follow me.
So
I haven't put that clearly. But
my lord's right. So you can either say, I've got to credit 92% of the RDS additional development, or you can credit the whole thing, but
deduct 8%.
But deduct the 8%. It's
Yeah.
the same. Yes, my lord. Yeah. I think we're agreed. So that.
Oh, right.
So it's I've not mentioned any law yet. I don't really think this is law, and I'm not saying I'm not going to go to any cases.
But the difference is this: say the building was worth £100, and you do the 60% loss of chance that you're doing to work out how much rent you've lost. If you did the 60%, you'd have a credit of £60. If, however, you say, no, it's actually there, and with a 92% chance it's only there because of the breach, you'd have to give credit for £92, not £60. So you should put it on the other side, but make some sort of adjustment to reflect the 8%.
Because if you put it in the 60, you have to put it in the 32. So yes, it has to be 92. And that's what the judge did. Put it in the 60 and he put it in the 32.
Yeah, but I'm saying it shouldn't be in the 60 because it's not 60%. It shouldn't
92.
be in the 92. It's not there either. It should really be the other side, but there's a quirk because there's just a chance, even if everybody had been on top of their game, it would still be the new shiny building. And what you ought to do is put it in the other side, but make some sort of notional deduction to reflect the fact that it's 8%. Because it's an 8% chance that it would be there, not a 60% chance that it would be there.
That's right, my lord. But it just depends. If you prefer to do all your maths for each probability, then you can do that.
Oh gosh,
or
I can't
not.
do probabilities.
You obviously have a preference, and I'm not going to. It's nice to know people have aesthetic preferences about arithmetic. My lord, just the reserved matters judgment, just to complete the point.
Sorry. This is a world, 100% world, in which the negligence has occurred, isn't it?
The negligence has occurred.
But there's an 8% chance it would have made no difference to anything.
Yes. In terms of loss or credit.
And I mean, just taking that a stage further, in stage of what happened after the company had gone into administration.
What did happen? Are you
No, sorry. The thesis is it that there is an 8% chance that if the defendants hadn't been negligent.
No, they had been.
They had been negligent.
If they had been,
it still would have gone into administration, and so the real world is the same as the
same
world.
course of events would have followed.
This is
no, but this is all on the basis that they had been negligent. If they had been negligent, there's an 8% chance of this building arising. No.
They had been negligent. There's an 8% chance of the revised scheme happening anyway.
Yes.
Not the original scheme, because
Yes.
control would not, Girish's clutches would not have been evaded.
So why do you not take it into account as a consequence of them being negligent?
Because it didn't change anything in the 8% world, because there's no loss. So if you imagine Ministry of Defence and Wheeler. Imagine Wheeler, my lord. There's some sort of discrimination, and you have a percentage.
Can we not talk about other cases that I haven't got in front of me, which I know less about the facts of than the one that we're looking at for 2 days?
Yeah.
Just bear with me on this one.
Ours is more complicated.
So they've been negligent.
Yes.
There's a 60% chance of one outcome, a 32% chance of another outcome, and an 8% chance of a third outcome.
Yes.
Why do you not take all of those possible outcomes into account when determining damages which you pay for the negligence, which includes them getting the shiny new building, an 8% chance of a shiny new building?
Because in the 8% world, you would have got the shiny new building even if they hadn't been negligent, so you can't pin any credit or loss on them. It could have been a 10%, £10 difference in value. It just happens to be £0 difference in value because there's no harm at all. It's a bit...
Sorry, I'm not sure I followed that last sentence. Maybe I'm just being unduly slow, but I thought we were always in the world of what would have happened.
We're always comparing both worlds of assuming they've been negligent. That's... So, sorry, maybe that's wrong. The present world is where they've been negligent, obviously. In the world of, I think I got taken down an alley. In the non-breach world is the non-breach. So they've been not negligent. If my lord said assuming they've been, assume they've been not negligent, then nevertheless,
the building might still have been there.
The building might, no, the world would have been as it is. Yeah, 8%. Assuming they had not been negligent. In other words, their negligence made no difference to the world on 8% of what the rest of things that could have happened. And it's always the way with a loss of a chance that you either might have got something nice or not. And the question is, in the not world, what would have happened? And in some cases, in the not get your nice thing world, you just get nothing. That might be a beauty contest. You just wouldn't have got anything. Or it might be that you would have just been in the same world you were in, which is the same as that. I would have had a less well-paid job that I do in fact have. So all you're then doing is looking at X% of your incremental benefit, which is what's happening here. There are some situations, is where you get into Richards and etc., where the wrongdoing deprived you of a chance of getting something good, but it also set you on a track where if you hadn't got that good thing, you would actually have been worse off than you are now. And in that case, that's when the maths becomes different, because then you've got the X% chance of an increased position, but a Y% chance of a worse position. And in that case, you would credit the full value of your present life and say, well, okay, there's an X% chance that things would have been worse, but I do have to give credit for the fact there's a Y% chance that I've avoided a worse outcome. So if you have lost litigation, there's an X% chance you would have won, payout, excellent. A Y% chance you would have lost and had to pay costs. But because of the negligence of the solicitors, you got to do neither. So you would have to offset the different proportions. And when you, all of the cases, and we do it with some care in the skeleton, all of the cases fit in, and I've even done tables, helpful or no, fit into that model. You just have to compare, always rigorously compare the breach world with the non-breach world for each strand of your tree diagram. And they're all explicable on that basis. And Mr. Stewart effectively accepted that, because when my Lord Justice Newey said, well, what if he was then saying 40% world, but what if in that case you still end up with the RDS? And he said, well, that would be fatal to my case. So he's accepting it depends on the finding on the 8%, what would have happened. If on the 8% world the answer is Barrowfen would somehow have had 0, then he is right. You need to credit the 8%. In the 8% world, you need to credit the RDS with that because it's a gain. My Lord, just to, I've said it before, but just to go to the supplemental, sorry, the Reserve Matters Judgment at 4 Volume 2, page 595. And if you look at paragraph 110,
Give me the reference again, so I was right.
not at all. Yes, it's page 595 of the core bundle, so it's the second bundle. It's the Reserve Matters Judgment. And it's page 110. Sorry, paragraph 110. And if you just read that paragraph, it's pretty clear. But it's all, as I think my learned friend said in the context of the other appeal, it's all about whether control would have been lost or not. And if it would, then Gearish would have followed through with his plan to put the company into administration. And that's why he gets to 60 and 32 and says nothing more about 8%. Because we say no loss. Now, my lords, other than law, there is only one other strand that I don't know if it's still live on this appeal. It requires us to go to supplemental bundle.
Before you do that,
Yes.
I would have to do it by reference to principle. What am I supposed to be doing? Because I'm not a contract lawyer or a tort lawyer. Mm-hmm. I must put the person into the position he would have been in had the negligence not occurred.
Please.
That's one of the principles I cling to in this stormy sea.
It's all you need.
And are you saying that if the negligence had not occurred, the building might have been there anyway? Because the position is more accurately that there's an 8% chance the building would have been there had the negligence not occurred, and a 92% chance that it wouldn't have been there. And that's what we've got to reflect. And I'm still hung up on the fact that you got a 60% deduction when you should have had a much smaller percentage attribution, if you follow me. I don't see why it's all or nothing. There we are. It might have been there for end of story, because why isn't it?
No,
some small
I
reduction?
agree. 92%. That's what the judge did.
That's what he did, is it? Okay.
That's what he did. He did it under the 60 and he did it under the 32, which meant he did 92.
Okay.
But my learned friend says 100% deduction.
Right. And
That's the
the
argument.
it is just the 8% then.
It is just the 8%. But the other point, I don't know, as I say, I don't know. It's in the supplemental bundle, tab 36. And this arises because we said, so paragraph 3 of my learned friend skeleton says this point's worth 1.3 million. and we said 1 point what? Are you sure? And then we asked them to explain it, and they did so in this letter, which is not a pleading, but it's all we have. And we say, and we go through this at paragraphs 27 to 31 in our skeleton, we say, well, this is fundamentally wrong, even if they're right about the 8%. Because we say this point is worth £200,000 because it's the difference between 100% of 2.5 million and 92% of 2.5.
In other words, it's 8% of 2.5 million.
Exactly. 8% of 2.5 million. But what the calculation does here is it says, well, and they've done what I did, separate rows for the different permutations. Primary is the 60% possibility. And they say, I've got my principal, which is the loss. Then I've got my 60% reduction. And then I'm going to credit the whole 2.5 million. Then I'm going to do it again in the next row.
Now that's the error.
Well, we say it must be an error. You're adding 2.5 million every time you've got a... If there are more branches on the tree, you'd be adding 2.5 million more times. I don't know if my learned friend still pursues the point that it's a 1.3 million issue rather than 200,000 issue. He didn't refer to that, and we do deal with this in our skeleton. So let's assume that's gone, and that it's a £200,000 point, about 8% of 2.5 million. So now I have to decide, subject to what you tell me, whether I should go to any of the cases. And we do that quite carefully in our skeleton. Maybe I should go to Richard's, because that's the one that my learned friend went to in detail. So I think I'll briefly do that.
The second Richard's judgment.
The second Richard's judgment is authorities, tab 14. So it's the second authorities. So, my learned friend, I think, has already told you, it's about sale of a tech company and some legal litigation on dismissal, receiving a payout. The negligence of the sisters meant that a particular issue wasn't raised, and had it been raised, the transaction wouldn't have gone ahead at all because no deal would have been done. And there was a 75% chance the claimant would have sold to somebody else for 8 million instead of the actual sale of 4.6. So the 4.6 million here was deducted from the damages, the sum actually received, that is, was deducted from the damages 100%, just flat. Why is that? Why is it not just 75%? The answer is that in the 25% world, the 4.6 million would not have been achieved. So it's one of those cases where you're worse off if your payout doesn't come out. So the 4.6 million, sorry, I think I've got that the wrong way around, haven't I? Yeah, that's right. No, that's right. The sum actually received was the 4.6 on the Duff deal, but had care been taken, they would have had a 75% chance of 8 million. But had the care been taken, they would have walked away, as my learned friend said, so they never would have had the 4.6. So it's not a case where you had a chance of reaching 8, but in default of reaching 8, you would have just ended up where you actually ended up. It's a case where, but for the negligence, you either would have done really well or lost out on where you actually are. And that's why the mathematics becomes different. If we look at paragraph 78 to 9.
So you say this, I mean, you do say this is wrong.
Well, it's wrong to ignore the 25. Something would have happened. But otherwise it's right. It's distinguishable from our case.
Sorry, what?
I'll explain in a second, my lord. If you see on paragraph 78, they say that here, unlike in Hartland Lacey's, it's binary. They would have walked away, but for the wrongdoing. Walked away from the 4.8 million transaction. So that means you have a world, the actual world is 4.8 million. The non-breach world is 75% of 8 million and 25% of don't know, but not 4.6 million.
Or 25% of zero.
Well, zero is what was awarded, yes.
But
My
you
only
say, well,
criticism...
there's no reason to believe the company became valueless. That's
my criticism, that avenue wasn't pursued. But it's logical that you don't get the 25% that you do get the whole 4.6 million, and you don't only get 75% of it or 25% of it, because
So you get the credit should have been the. So what's the credit, you say?
So what you have to do is, again, you have to compare the different, the 75% world and the 25% world. The 75% world, I've got 8 million, I would have had 4.6. The 25% world, I've got nothing, and I would have had 4.6. So I'm actually worse off. Now, my criticism in the skeleton is someone should have thought about that 25% world, because it can't be nothing. But it certainly can't be 4.6 because they have walked away from that transaction.
So yeah, that's why that last sentence
Yes.
you said I think wasn't quite right.
Undoubtedly. But I don't have a
Okay,
transcript.
if the neither do we, unfortunately. If the negligence had not occurred and the correct advice had been given,
Yes.
it's 100% they would have walked away.
Yes.
That's no doubt. Walk away.
Walk
so
away.
we can now just completely park the 4.6 in that non-negligent world.
Yes.
So in the non-negligent world, there's a 75% chance.
They would have done the 8 million deal.
Right.
But there's a 25% chance not discussed, but clearly not the 4.6 million. So it's not like our 8% where the backup is you're just back in the real world and life continues as it has. You're in a different world where you've walked away, but you've failed to secure the 8 million deal, it fell through or whatever. So therefore the maths has to be different and it's explicable on that.
But in the actual world, they've got 4.6.
Yeah. So you can credit the 4.6 and you don't need to worry about how, if I credit the 4.6, what about the 25% world? Wouldn't I also have had the 4.6 there? Because you wouldn't.
Right.
So that's the point. There's no loss permutation.
So the 25% chance of getting nothing balances the
Partly.
fact that you're only dealing with 75% of the larger figure.
Yes.
Yes, in fact, the error you say isn't actually in the crediting the whole of the 4.6. It's in not figuring out what the result would have been in the 25%.
I think so. And we do a table of those possibilities. It's 2 lines only, and it's at page 20.
Does that quite work? Because 75% of 8 would be 6, and 25% of 4.6 would not be 2.
Well, they didn't. They did 25% of 0. There was 0.
But if you follow your tree diagram, the 75% line leads to losing the difference between 8 and 4.6 or whatever. The 25% line leads to losing 4.6.
Yeah, so you could have done 75% times 8 minus 4.6 minus 25% times 4.6.
And it wouldn't come
That's
to 0.
what happened. Yeah, and the damages weren't 0. Sorry, no. The 25% was treated as 0.
But you wouldn't end
That
up-
is what they did. That's what the judge did. What you just said, my lord. And so you end up with 75% of the uplift to 8, but you have to credit the full 4.6. So in the 25% world,
You're probably right.
It is, that is how it is.
Yeah.
So where do you say it's in your skeleton? You've got to.
So we deal with that case at paragraph 62 to 69. And there's a almost a table at paragraph 67, and that contrasts with our table because there's no world where the non-breach and the breach positions are the same, and in fact, as you can see, the 25% world, the non-breach position, the position you're supposed to be compensated for not having achieved, is actually worse. And then at 68, I raised the criticism that my lord mentions, which is I wonder what about the 25%, but it's not a criticism of giving a flat predicate of the 4.6.
Yes, I see.
I don't think this second judgment was available. Oh no, sorry, that's it. So, if I may, I'm gonna rest on the cross appeal unless there's anything more, and make a few reply submissions on the appeal. So I think it's about 6 topics, but the number may be different by the time I get to the end, especially if my lord's saying it. My lord, the first topic, it's probably worth looking up the Bungay case, maybe the only case that I pull up now, but it's Authorities tab 4. Now, my lords, you're in great peril. You're in peril of getting the law seriously wrong. Luckily, I'm here. And my job is to make sure that doesn't happen. I can't probably take you all the way in the next small amount of time, but I've just got to show you the peril. My lord, if you look at the Bungay case, and the paragraphs that we look at are the ones that both of us have gone to. But
what are we looking at this for? Give us a clue now.
The clue is, what is this market value principle, and does it have any relevance to our case?
That's what we're looking at, okay?
Yeah, sorry, signpost, perhaps.
Yeah, might help, yeah.
Page 85. And there are going to be, I think, 2 points to deal with within this. The first is the more involved. The first is that Mr. Stewart says, well, what triggers a capital valuation is just the presence of a commercial decision or option. And I say, well, that's completely wrong, at least in general terms. And further, my Lord Justice Lewis in particular cavilled at my describing a deemed sale, and my learned friend was happy to.
Well, I saw it as a valuation of an asset. That's all.
Yes.
I mean, who am I to say at this stage
Exactly,
of the game?
my
Yeah.
lord. And the answer is, well, we don't just value assets, and that was the betterment cases, but we do often deem sales, and I'll show you that that's what this Bungay principle is doing.
Yeah.
My lord, so the key thing to understand is the only situation that's being considered within Bungay and the very familiar market mitigation rule, and however one wants to call it, is that where the claimant has a contract with the defendant to buy or sell or to charter, one of the foremost cases that's cited there is the Elena D'Amico. That's a charter party case. What happens is the counterparty breaches, which means that the claimant needs a new buyer, or they need a new seller, or they need a new charterer, or they need a new vessel. And if you read paragraphs 79 to 80, you'll see that what it says is a decision to stay out rather than re-enter the market is a break in the chain, because wherever there's an available market for a substitute contract, and this reflects the choice that first existed at the time of the original contract. So, my lord, you have to read it upside down and very fast to read that as a principle that if you can sell to someone, or you have a general commercial decision, you value the capital. The point is that C has, let's say, contracted to sell to D. D has repudiated. C is expected there to replace. It's a cure effectively replace D with another D, another buyer, seller, charterer, ship owner. Replace the contract. And of course it's obvious that in that case you have to go and replace them. Just as you typically should cure anything else promptly. Go out and replace it, fix the leak, don't just let it flood your house and claim damages for that. So the very contract between the parties is buy, sell, charter, which means rent.
Actually, you don't have to.
Yes? Sorry, Mark, go on.
Okay. You don't actually have to go out into the market. The simple point is that damages will be assessed as if you did.
Yes, exactly. Because there is no duty to mitigate. There's merely your damages are limited to those that the reasonable person would be assumed to have done.
So
yes.
The simple point is if you don't, it's down to you. And the
yes.
law will assume when assessing damages that you did.
Yes. And it's a failure to go back into the market you were already in. It's a failure to re-enter the market to get a substitute contract. And in that case, that's why I say it's a deemed sale, because it's the failure to make a sale and your damages are quantified as if you went and did the sale. But as my lord says, no one's saying you have to do it, but that's what your damages will be restricted to.
A different way of putting it is what is reasonable in the context. This is the context where person A has agreed to sell to person B, and it would be reasonable to expect them to do that, and therefore you'll measure it accordingly. Whether or not they actually do, whether they say, I've had enough of dealing with other people, now I'm going to live with the hermit in West Wales, is entirely up to them. But it's a measure of what would be reasonable in that context.
That is absolutely right, my lord. And I'm not saying it only applies to buyers and sellers and charterers, but I'm going to come to that. But that's what the principle of the available market is, applied day in, day out in international markets and arbitration and wherever English law applies.
But we've all got a little bit of, I mean, in a sense, we've got sidetracked onto this because there isn't the real question is whether as a consequence of result or within the chain of causation of the negligence of the defendants, you've ended up with something which is valuable.
Absolutely not. No. The question, and there is a question, and my learned friend could win if he were right about the answer to the question. The question is, given your actual losses, and having a value is not a loss, that's what the betterment cases show you. The loss is the rent and the costs and all of this. It's actual money. But, given your actual losses, is there anything that you did that broke the chain of causation that means you have to deem a sale here? And that's where you get to the valuation, because by deeming the sale, or whatever you want to call it, you crystallise a capital value as if you'd sold it. And you haven't sold it, but you crystallise it then. But otherwise not. You don't just say, well, I've got an asset. What's the capital value?
I thought the cases show that if as a consequence of the negligence for which you're entitled to claim damages, you also receive and I'll use the word monetary benefit.
Yes.
That you have to bring that into account.
So if it's an incontrovertible cash, then yes.
Cash, yes, we know you'd accept that.
Yes.
But this is what's wrong with the answer that this is a development which was always just a way of generating cash?
Well, you have to go down the right route. So the law will entitle you, my lord, if I may say, will entitle you to say, and remember that you have to reconcile, you can't have lost twice. So you couldn't say you have a capital value and you've also have a lost rent. So you've got to work out.
Your clients are not sitting on this development and saying, ooh, what a pretty development, we'll just look at it for 25 years.
No, they're earning money.
Yeah.
So let's credit that money. Unfortunately for the defendants, they're paying finance costs, which, whilst still less than the money they're earning, give a net profit that's smaller than the one on the previous occasion.
At some point, you better come to that, because now I've realised that
your equity cost point, my lord.
The calculation includes an opportunity cost. I would like to understand that.
Fine. Yes, my lord. So we say, if you receive incontrovertible benefit, which is cash or something you actually sell, or
you could sell,
or not could, but intend or will,
well,
because
you intend to realise money from this asset, whether it's by sale of a long lease, sale of a part of a flat, which is to a housing association or otherwise, when you say your clients are not just sitting there saying, "Oh, what a pretty building." I mean, this was always a something which would be disposed of by way of the grant of derivative interests.
So for my learned friend to win, what he has to do is say, I know it's 2024, but it's really a bit of a jury question how you value things. It's fact. You can value it. These are investors, so let's value it. But that's not what the law says, and that would be a mistake. What the law says is, if you get cash out of it, reduced coal costs, increased rental, then that's what you credit. If you actually sell it, then that's cash. If you intend to sell it, that's effectively cash. It's just cash in the future. That was the pontoon.
Have your clients sold any of the residential properties on a long lease?
I have no idea, but certainly. So, well, this takes me to the second point.
And also, do we know about the hotel? We may not know about one of the cuttings, but do we know about the Premier Inn 2-2?
I think that's.
Well, that's been.
Has that been a long lease?
We've sold nothing, I'm told. The 25-year lease.
Well, okay.
25-year lease of what? Sorry. Of the
The
hotel.
hotel. That's what I thought somebody said yesterday. that it was
You've
a long
sold
lease.
a 25-year lease.
But that's what the valuation is on. You take in the whole valuation was.
But this framing of the whole question about do we retain the asset or sell it is missing the point, or it's just.
It is, my lord. It's missing the point because the point is, what did you do? Actual losses. So let me
Just before you do, so I understand this bit. The 25-year lease is for a capital sum.
No, it's an annual monthly rent.
And what about the social housing?
Yes. That's
That's
got to be
fine.
sold.
That never got sold. We bought it back from the council.
They
Well,
bought
you
it
may have
back from the
bought it
council.
But you can't buy it back
They
until you've sold it.
But it was always assumed to be sold.
But you did sell
So
it.
the social housing was sold.
The damages allow for that. Yes.
What do we mean damages allow for?
It's still in our hands because it came back for reasons.
No, I'm not asking whether it's been around the world and reparked in
Did we
Tutti.
sell it?
Did it ever leave
Did we
your
mark the
hands?
title to it?
No, we didn't because nobody wanted to buy it.
So it has, if we ever checked, we would find that you've always been the registered proprietor and nobody has had any other kind of legal estate in it.
Those are my instructions. See, the problem with the deemed
So
sale,
they're all just sitting empty.
No, they're rented out. They belong to us.
they're rented out now.
So you have sold some leases.
Well, they're
Monthly rent.
to get rent, you have to have a lease. You can call it sold, but it's a lease.
This is what I'm trying to demonstrate.
Yeah.
This whole concept of whether we retain or whether we sell is
No,
just trying to put everything into a
exactly.
box marked sale or retain.
I agree with you there, my
It
lord.
doesn't work.
The boxes are marked actual and deemed. What you get in every case is your actual losses. So you say to the person, what did you do? And they say, this one I rented, this one I sold, this one I did this. Let's say. Now, the problem we had here, the accident of this case, is that the date of judgment was the same as the date of completion. Let's imagine that we were quantifying the loss in 2026, 5 years later. So in 2026, I think I wrote this down somewhere, but I'll just say what I was going to say. In 2026, we're claiming our losses, and we say we've lost rental profits from 2016 to 2021. You know about those. The rents, but we also had to pay our finance. So we net profits, that's what we've been awarded. And our lost profits went down from 2021 because then we had a counter stream of, in actual world, we had rents and finance. So we actually had suffered a much smaller loss per annum.
You might
That's
not
what
have suffered anything. It all depends.
Well, the judge said that we did on that analysis because of allowing for finance, which is what this is about. But perhaps, never mind whether we did. In that situation, we claim historic rental losses from 2016 to 2026, of which the first 5 years are substantial, the next 5 years are small. And then we'd say, well, to claim the future, I'm just going to have to do a net present value because that's what courts have to do. And in that case, you can look at intend because that's what courts have to do. What are you going to do on balance of probabilities in the future? Then if you believe the witness in 2026, then that's how you measure what's going to happen. Same with, are you going to try and get a job? Oh, I'm going to get promoted.
So if you accept that after completion and we come to a trial after completion, so we avoid the, as you say, the accident of the two being relative.
Several years after completion,
Okay,
yes.
So let's just even look at it today. Today,
Yes.
your client is receiving money, actual money,
Yeah.
from this development.
We have no problem with crediting the rental income, providing it's not what we wanted to get into because it was a much simpler case when we were just claiming a previous period. But we have no problem with crediting the actual income up to the date of assessment and then the future income, providing we take into account our actual costs, which includes the finance, as they did for 2016 to 21. That's not a problem. And if some, they're not, but if some were sold, then it would be the ones sold.
Right.
And if some were rented, it would be the ones rented.
So reading round one of your notice of appeal,
Yeah.
which is ambiguous,
Are you coming to the do I accept development profit point?
correct?
So that's why I wanted to raise this. So no, we do not accept development profit. It's just because of the dates. On my example, I say, well, let's look at all the incomes and outgoes from 2016 to 21, compare the actual world with the would-be world, and that's our claim, plus net present going forward from 26. And my learned friend says, no, it's development profit in 21.
That's because everybody knows that, yes, you characterised this case about that it was your client's, that we always intended to keep this property. What you always intended to do was to use it for profit and maybe keep the freehold title, but grant leases. In fact, some of the property you were supposed to
Yeah.
sell. Obviously, maybe
there's
it
no
hasn't
market.
turned out that way, whatever, but you were supposed to. And so, in a sense, isn't that what the valuer is doing? At the judge arrived at in determining the developer's profit.
No, that's exactly my point. That is what the valuer is doing the best he can,
Yeah.
other than the finance costs. And that's the cavil. And that's why, then when my lord says, so
Yes.
you do accept developer's profit so far? Well, no, I accept a net present value of forward, but it has to include finance costs. But given that both dates are at 2021, it looks like what they call developer's profit.
But it's clear,
Yeah.
because the way your grounds of appeal
Yeah.
were framed, on one reading, it could be that you just didn't accept development profit at all.
I
in any
don't.
circumstances.
I don't accept development profit, but I accept a net present value. Developer's profit qua a sale value, a market value to sell, because of the presumption of sale. But if my lord's using developer's profit in the sense of a net present value assessment of all future income streams, then I have no problem with that, providing we bring finance in. That's not what my learned friend means by developer's profit, because he means a deemed sale or a market value. And we say, well, that's irrelevant because we just look at actual. And we don't need to get into what I intend to do. We just evaluate
No,
actual
just
losses.
Just valuing something you've actually
We
got.
evaluate actual losses going forward forever, and they have to include costs. Actual losses, unless the chain of causation is broken. And if the chain of causation is broken and the burden is to show that, well, then we have to get into why was it broken by not selling? And that's where my learned friend has to do. He has to invoke principle of legal causation to say, despite what you did, you broke the chain. And therefore we ignore finance, because then we're in a deemed sale world rather than a measuring the future world. So that's the state of play. The actuals, people recover their actual losses based on a myriad commercial decisions that they make. How am I running my mill shaft, and which plasticine customer do I decide to have? And they recover them all unless the defendant stands up and says, you did something that breaks the chain there, or is too remote, but we're not arguing remoteness here. And only then do you cut in. So there's always commercial decisions all the way. Now that takes me to another point, because I do want to get through my 6 or 5. And that point is that, and sorry, just to finish the Bungie point, we see from the buy and sell cases that what you're deemed to do is buy or sell because you're replacing a buyer or a seller. But with a charter party, what you're deemed to do is find another charterer, in the case of New Flamenco, or another ship owner who will charter to you, in the case of Elena D'Amico. So there's no selling, there's no capitalisation at all. There's a substitute contract for the contract you lost. Why? Because that's what the defendant was going to do for you. And indeed, if in that situation, when you're supposed to substitute a charter, you actually sell, well, that breaks the chain in New Flamenco, because you're not re-entering your charter market, you're going in some new market. So if you want to invoke the Bungie principle, I say, what market am I already in? Did I try to go in, fail to get in, but now have to re-enter? And there isn't one. It's not the revised development, because that's brought in already. The question is, after the development, why am I selling? Why is the market for selling ever a market I was in? So that's what we say about the Bungie principle. And I'll come back to how you could use it here otherwise, but I just want to deal with the nexus point. So Mr. Stewart says, well, the nexus, there's no law for this, but the nexus is broken once the development's completed. The wrongdoing was in the delay. Now, we say this argument was retrofitted to try to justify a 2021 date, but it doesn't fit. Proves too much. My learned friend said, the award that's being made and which you're considering are what damages to award Barrowfen for not being under the control of its shareholders from 2014 to 16. He's right about that, as in that was the wrongdoing. But Barrowfen was freed in September 16, and Stevens and Bolton ceased to be instructed, I think, in December 15. This was all before the development took place. So there's no match, if that was the nexus, there's no match between when we were freed and the completion of the development.
Well, your claim is for loss of rent as a result of delay.
Our claim is for all the consequences of delay, but we just claim rent. But if we're going to get into all the other consequences, both parties accept the consequences are that you ended up with a different development scheme. We claim that because we claim the cost of having to do it, and they rely on it because they want to credit it. So it's not just that we got the same rents but later, it's obviously that we had a different scheme, and one has to make that fall where it does by measuring it.
But I mean, I follow that, but
Yeah.
your actual pleaded loss was loss of rent
Yes.
because of delay.
Yes.
So then the question is, do you bring into account on the other side the fact you've got a better scheme?
Well, it's only on the other side if it's on the other side. It could be on your side, we just didn't claim it.
Well, in circumstances...
Depends what you mean by better.
Claim
It's
it.
better, yes.
Yeah.
It was ultimately less profitable in ongoing costs versus additional development value for reasons that are in that table. It was also less profitable, and we don't want to get into economics too much now, but we totally reject the Canary Wharf example as nonsense. The aim of investment is percentage return, and it's not about absolute size. Because the more you invest, the more you get. You want a return. If I'm going to invest in a fund, I want to know what the return is. And if that fund says, we invest in 4,000 garages because they make 1,000% profit, that's much better than a fund that invests in Canary Wharf. So it doesn't make sense to say, well, of course I want the £100 million Canary Wharf because I'm going to make more money. But how much do I have to deploy? What's my return on my capital? That's how investment works. So here they had to deploy more equity, which is why they were awarded the opportunity cost, the alternative that they would have made on having invested that equity. And that is not challenged as a legal principle. And I don't think I have time to go to it, but...
So just to be clear,
Yes.
translating all this into...
But it's at 71, just for the transcript. It's at 71 to 71 and 74 and 76.4, where the judge says, I accept you've lost out, you've had to invest more millions of your cash, Barrowfen, and therefore you get a loss of use for that, for the equity. Sorry, my lord, but I did interrupt you.
You've got in mind that table, wherever it is.
The 959.
This is... Remember the different lines. This is C558 in the
Yes.
Reserve Matters Judgment, giving rise to your negative developer's profit.
Yes.
Uh,
We only have to do this because the trial was when it was. If it was in 5 years' time, there would be actual rental income on revised scheme, actual rental income on original development scheme, actual finance costs, and then there'd be a net present value going forward. But so all this is the net present value of those future streams. I want to have that in mind.
So just so I'm clear, we see developers' profit frozen at a particular point in time, giving rise to the credit. And you say no, because that doesn't take account of all the future costs, which we would have incurred because we've gone on holding this property. So
No, that we are incurring, will incur, matter of fact,
well,
and would have.
we
This has to be an award for
in
actual
25 years' time, we might find out whether they were actually incurred.
The court always has to take a
Quite.
view. Yeah.
So, but anyway, so you're looking forward over 25 years,
Yes.
saying we're going to incur these sums. Now, you say, as I understand it, that means you knock out entirely the credit.
Yes, just on the numbers.
On which numbers?
These ones in your table here.
Because
Because it's slightly obscured by the fact that it's net present value, but all this is saying is, and even the developer's profit is itself a differential between two things, as we've seen. It's a profit. So what you really are doing is you're taking all of the rental income going forward into the future, which you can net present value to a GDV, and you're taking all of the costs of that you have to net present value, and you're finding some sort of difference, and you're saying, also I'm going to have to pay going forward, I'm going to have to keep paying finance. I actually get a bill from the bank for interest every month, and I also continue to lose use of my additional equity that I would have had in my own bank.
yes, I see.
And
So
then
just-
and I just bring them back to today.
And
It
I
would
think
be...
I do follow the way you put it.
Yeah.
Just to be clear, as the equity element, do we
Yes.
find that explained somewhere?
So that was those paragraphs I just barked at you a moment ago.
Which were
70 something, and 71 in the reserve matters, 71, 74, and 76.4. There's no respondent's notice challenging this, saying, well, even
No.
if we're right, there's a problem with this. And the judge says, well, I accept after, and there was a lot of argument about this, a lot more than about this key point.
yes.
So, a 959 as a net present value is small. In other words, the annual differential overall ends up being not that large. And no one would have known this. You couldn't have told whether you were better or worse off. My lord says it's a shiny development, but you don't know. Compared to your, my learned friend says, 40 million. But 40 million with 10 million extra costs and extra equity. So you can't just compare the headline figure. Is this more profitable? No one knew. No one asked. There was no valuation because the post-development finance is automatically built into the prior finance. You don't even need to value. And then if you're going to say, well, could is enough, there's got to be an available market. Was there an available market in COVID times? Turns out not for some things. But it wasn't looked at. The experts gave no view as to available market because that wasn't a question ever asked. Because it wasn't about deemed sale, they just did a value. So once you appreciate the only legal principle you can use, which is chain of causation, failure to sell, then you have to say, well, they just didn't make the case out that there's an available market, that it was the wrong decision. And I accept...
I would have expected, I mean, if you're valuing something, if there's no market, the value is nil. I might have a marvellous, but
Yeah.
cracked, repaired and glued Qing Dynasty pot, but if no one's going to buy it, it's worth nothing, is it?
Yes and no. Of course, that's right. But the way the valuations worked, of course, they looked at yields and general demand. But there was no actual discussion
Lord, I do object to this line of thing. These were both Red Book valuations. At no time was it suggested that one of the reasons for not looking at this was lack of an available market. All of this was being put forward on that basis from beginning to end. It wasn't pleaded, it isn't put forward, and it's not in the reply. It's the speculative line in relation to the difference.
All right, my lord, let's put it another way. There was no examination of what the reasonable Mr. Patel and Mr. Patel should have thought about. There's just the word could. You've seen the reasoning. And we say, okay, if you're substituting, you're replacing a sale with another sale, the Bungie case, well, you don't need to get into that. Obviously, you have to go and find another buyer. But in a professional negligence case or a misrepresentation case where the wrongdoers are on the sidelines, there's no automatically following that one should sell or not sell. You'd have to look at it, and I showed you ESSO. And
can I just explore this one moment?
yes,
I know you'll say
I'm going to have to sit down as well, because it's not fair to a learned friend.
Yeah, I know you'll say this is entirely irrelevant, but just so I'm clear in my own mind. Plainly, no one suggests it's unreasonable for your clients to keep the property.
Yes.
But you don't suggest it would be unreasonable for them to sell it.
Well, so that's a moot point. I wondered about that. It could be the case, my learned friend is quite right, that in all circumstances there's a range of reasonable. And it could be the case that selling it or keeping it would have been reasonable. If that's right, I win, because we didn't sell it. Well, we did one of the two, I should say. If we had sold it, then it becomes important to decide whether selling it is within the range of reasonables. On New Flamenco, it may well not have been, because you've cashed in a business, and the defendant will be entitled to say, well, where did that come from? Why did you choose to do that? Now, the nexus point doesn't work, because
that can't be right, can it? I mean, in circumstances where on your figures,
yeah,
you could deploy your money better elsewhere, it can't possibly be unreasonable to sell it.
Our figures do not say we could deploy our money better elsewhere. They say we would have been better off with the original development.
Yeah, but I think the point my lord's putting to you is if your figures now say you're losing money effectively on this,
No, they don't. Sell it. They don't say we're losing money. That's not what they say. They say we're making less money than in the other world. But Mr. Patel in 2021...
but the other world is gone. You can't have the other
exactly.
world
Mr. Patel in 2021 isn't worried about what he would have made in another world. He's just got his profitable development, and he needs to decide what to do. But he doesn't even think about it. He earns rent.
Can I get away from this again? This concept of sell or not sell.
Yes.
It's something you said recently. Assume that the question is simply, what is the value of this property and the future? It's a revenue earning thing.
Yeah.
Right? And you said, we're perfectly happy to have credit given for the capitalised value of the revenue streams of the future, provided you say, which is your primary case, I think, that you also take into account the financing costs.
Yeah.
Now, when you value the thing, and as the valuers did, to derive the developer's profit, which gives rise to 2.5 million, they do take into account...
This is my lord's yield point. I'm glad you raised that.
Correct.
So that is nonsense.
Okay.
In this sense, do they take into account borrowing costs? Yes, but not in an interesting way. So, if I'm going to buy a house, and I need a valuer, and the valuer is going to value the house, it might be worth £1 million, but in a low interest rate environment, it might be worth 1.1, because it's cheaper to borrow, and so people have more access to money, and their appetite for risk is greater because their risk is lower. And so in that sense, in the sense of, is it a low interest rate environment? What's inflation? What are alternative investments? What are borrowing costs generally? Yes, that affects yield. But the valuation of my house remained, let's assume I would get, a normal person would get 750,000 borrowing. The valuation of the house is still £1 million.
I'm not sure this is an entirely helpful, with respect, it's not an entirely helpful example, because we're not dealing with a house here, because houses are valued in a different way from a development.
Well, what I'm saying...
Where you're dealing with a commercial development, I mean, unless you are actually selling, in which case, as we saw, you use comparables.
Yes.
You are using the discounted value of money over receipt of money over time.
Yes, but what you...
And you do feed into that a yield figure based in part upon financing costs of the presumed purchaser, because that's what you're dealing with.
But not as a number. It doesn't. You don't end up with the value. The value of the
No,
development.
it's factored in through the number of the years.
But the value
through,
of the
through the yield.
The value of the development at 40 million is not the net equity you'll expect the borrower to have, and it's not the net profit that they will get. Each business will run its investment its own way.
It's what a purchaser would pay in the market.
Yes.
For that income stream, taking into account the fact that they will be incurring cost in making that payment.
That's right.
Why doesn't that take into account the financing costs in a sense that your client would be if they keep it?
Because you don't deduct the costs, you take them into account in the sense of appetite. The buyer says, I need to make X percent to be worth doing, and given borrowing costs, I'm going to expect a yield of this, or I'm not going to go into it. And so that will inflate how much they'll pay, or will deflate that. But they're not paying the net difference between their borrowing costs. So it takes it into account, my lord is right, but not in a relevant sense that means there's double counting or...
But that is what I'm sort of putting to you. Because you're saying that it's a sort of, you can't have, the goose without the gander, or the sauce without the whatever it is, I can't remember, but you can't have one without the other. You're saying you can't take into account, for discount purposes, the revenue flows without taking into account the financing costs the company will incur. But the value has already, at the moment, I do wonder whether the value has not already, in some way, through this concept of yield, taken into account the finance costs.
Well, all I'm going to say, and I think I need to shut myself down, is two things. One is no.
One was nonsense, I think.
I think I said that before.
I wrote that down.
But I tried to finish on a more conciliatory note. No, it does not deduct the costs you're going to have to make, and the reason why it allows for it only in a market sense, and I've made that point, and my lord doesn't quite agree with me. And the second point...
I don't know, I'm just listening at the moment.
The second point is one can see that from the fact that at paragraphs 44 and 45, and it's elsewhere as well, and I think I've shown you in the reserve matters judgment, it's accepted by the valuers that on an investment basis, you would add in the finance costs to your GDV. Well, that wouldn't make sense if there was overlap or double counting. So it's accepted there that that's what you would do. RICS, there's guidance notes. We haven't had time to go to all of this, but that shows there's no double counting. My June is showing me it, but I'm not going to show you. It's not fair. My lord, we could go all day, but we can't.
We have almost.
Yes, exactly. And I apologise, my learned friend. He's got to still reply on the cross appeal.
Yes. Thank you very much, Mr. Stewart.
I'm tempted there, I might
There's the interest as well, sorry.
Repeat myself in arguments. I am going to restrict myself to replying on the cross appeal. Save only if your lordships have any burning questions in relation to the appeal. But
no, I think you're right, Mr. Stewart. You've had your say
no,
on
I
the
have
appeal. And,
I'd only have,
yes.
frankly, I'd only have a right in relation to anything which had been raised new
yes.
in what's been said. It hasn't. And I'd also, frankly, only be repeating things that I've already said at least once. So tempting though it is, when one has the last word to try and slip it in, I'm not going to do so. My lord, I'm also going to step, I'm afraid, on my learned junior's shoes just to deal with interest by way of reply quite shortly, simply because we are at 4:13. And I'm going to reply very briefly in relation to the interest points first, because they were dealt with first by my learned friends. And can I just take the learned junior's very helpful diagram, and can I please ask you to have out the supplemental bundle, and go please to page 314 at tab 30.
Supplemental 314.
Yes.
Tab 29 in my...
Oh, sorry, it's tab 29 as well. I'm sorry, it's my fault. It's the last page. of a letter from my instructing solicitors on the 17th of May of 2023. And can I just show you two figures which you will recognise. And those two figures are the what is said to be a summary of calculation for the lost opportunity of claiming interest as damages claim. That is what you referred to in discussion with my learned junior as being damages. And the first is £337,229 up to the 22nd of June of 2022. And that is the claim for loss of use of the money formed predominantly by the rents, but not entirely, because it also takes into account the need to expend money earlier on, but predominantly by the rents, from the point at which they were first not received in 2016 through up to and including the 22nd of June of 2022. The next figure, 25th of May of 2023, is the figure of £520,014, and that is the figure which the judge also awarded.
And you say also.
Also awarded because if you go to the second bundle and the agreed note of the judges.
Well, if you go to the order, it's almost better because the order makes it clear. The first paragraph of the order is two mysterious sums. 1.7 million, which we know is a cheque that was written in September, whatever. The second bit, which doesn't have a name, is the 520,000.
That's right. And you also see the two sums, just your lordship is right.
Yeah.
Can I just also show you them in the note of the judgment?
Mm-hmm.
And the two sums are to be found in the last line, C609, compound or simple interest. And so the figure of £337,229 is taken as the figure for interest from this letter, and that is the red figure on my learned friend's diagram. It runs up to June of 2022. The figure in the yellow is the the figure in the yellow plus the red is 520,000, and what that means is that he has awarded 182,000 extra pounds for the period from the 22nd of June 2022 through until the 24th of May of 2023.
And just remind me what he's ordered that as and on. Is that the damages, which we've got loss of use, and on what figure, what underlying figure?
The calculation comes from the letter of 314, and what that is therefore doing is giving damages on the entirety of the awards of damages without giving any credit for the credit, i.e. the 2.5 million.
So that's the loss of interest, sorry, that's the loss of rent.
Yes, and everything else.
And everything else, and without including the credit.
Without including the credit.
And forgetting to credit the 1.7 that's already been received.
Yes.
Yeah.
But I'm just getting it, I'm very confused again. But is this reflected in the order? Because the order gives £520,014. And indeed, Mr. Folkard's diagram shows red and yellow making £520,014.
Exactly, but the way it's made up is it's one way to look at it is it's the 520 less the 337.
But he's not double counting. He's taking the 337 up to a certain date and then
yes,
that's
a fair way of looking at it. Now, my learned friend makes two essential points about this. The first is that it's illogical for us not to have appealed the decision in relation to the receipt of the credit, because he effectively says, well, if you were going to say that the credit ought to have been included, then you ought to have only had damages up to the 31st of March of 2021, which if you look at S314 would have been £222,000, and there should have been a different, much lower figure from March 2021 until June of 2022. Well, my lord, there it is. We've nodded, and they've got whatever the extra amount is by way of damages, and we haven't appealed in relation to it. And your lordships don't need to trouble the scorers in relation.
Can you just remind me, what are we actually arguing about? They accept that they're going to give credit for the 1.7 million, so you'll have to recalculate this. So what is it that you're actually objecting to?
So the effect of this is effectively that it's a £167,000 point.
Yes, and that £167,000 is charged for what that you say you shouldn't be?
So that £167,000 is the difference between making an award on interest just on the £337,000 to June of 2022, as distinct from, and in broad terms, that would be 15,000 odd pounds.
It's the difference between the damages, we call it the damages, that's what you're talking about, isn't it? Yes.
Sorry.
So that confused me immediately. So it's the difference between the damages on what?
It's the difference between an award, and this is of interest, and damages of 337,000, which would be 15 odd thousand pounds.
As compared to the 4.5 whatever?
Yeah, essentially, yes. And the first point my learned friend makes is he said, well, you're being inconsistent because you could have taken another point. And the fact of the matter is I completely accept we could have taken this point. In fact, in logic, from March of 2021, they had a different, better asset. Bully for them, they've got 70 odd thousand pounds more. I'm not going to be applying to amend my appellant's notice and so on and so forth. But when you actually ask the learned friend, what on earth is the justification for giving it a further award on this sum, I didn't mean any disrespect to him, but answer came there none.
I mean, in the real world, I'm sure this isn't in the papers anywhere, presumably they were already receiving rental income by mid-2022.
Quite. Yeah, but in the real world, that's absolutely right. But that's where we are. And that's all I propose to say in relation to the interest appeal. That leaves me with our appeal in relation to the credit. Can I sweep some things out of the way? My learned friend teased me with whether or not we were going to say this is a £1.3 million point. He was right to tease me because we don't say it's a £1.3 million point. He is right that on the maths of the judge, what the judge has done in the postscript to his judgment is effectively give credit for 60% of the award against the 60% damages, for 32% of the award against the 32% damages, and therefore he is right to say that what this comes down to on our appeal is somewhere just south, I think, of £300,000 or thereabouts. We can do the exact maths, but he's right about the maths. And
it's 8% of the developer's profit.
It's 8% of the developer's.
That's all we're talking about, is should they have had a notional credit in some way, call it what you will, of 8% to reflect the fact that there's one bit of the universe where this might have happened anyway.
Yes, Mark.
Yeah.
That is what we are. That's on the maths what we're talking about. So that's sweep that out of the way, I hope helpfully. Secondly, however, can we just examine, because actually, as I understood my learned friend's submissions, he and I weren't too far apart on how you actually approach this as a matter of logic. Where we did part company was how one should apply to the facts. And can I just do two things? First of all, can I please invite you to look and see what the 60% and the 80% relate to. And the error of logic in my learned friend's case is that because he has found, sorry, he, the judge, because the judge has found that in the negligent world, following, as it were, a 60% chance that the development would have gone ahead because of the company claims, and a 40% chance that the development would have gone ahead in different terms on the Administration Act claims, the only thing one is looking at is an 8% chance which comes about as a result of the possibility that even after you've gone through that, you still end up with the original development. And in my submission, there is a logical flaw with that. And when one exposes the logical,
so when you say end up with the original development,
You mean the revised, I
I'm
think.
sorry, I'm getting even more loose-tongued than normal. I shall be standing for Vice President of the United States before too long if I'm not careful.
President, there's a vacancy.
I don't have the necessarily natal qualifications, but anyway, the revised development scheme, yes, you're absolutely right. The fallacy is this. At the first stage, there is a 40% chance which covers all sorts of different possibilities. And one can see just how enormous those different possibilities are by looking at the counterfactuals at C444. And where he goes through the various different counterfactuals. And the first is what would the independent advice have done? And he says it would have been likely that the independent advice would have been to write up the register properly. Then he looks at what the court advice would have been, and he finds that it would have been probably that the court would have been prepared to make an order for rectification of the register at 590, less certain that that would have happened without consent. Third, would Girish have taken independent advice? And can I just show you at 592, after his evidence, this evidence was obviously self-serving and I attached a little weight to it. Nevertheless, I've reached the conclusion the real and substantial chance that Girish would have followed S&B's advice and the advice of any independent counsel, because, now just pausing there, just look at that possibility. That carries with it the prospect that Girish would not have accepted the independent advice. At that point,
I have lost where you are.
I'm sorry, my lord. Paragraph 592 on page C446.
Thank you. I'm sorry.
That carries with it the prospect that Girish would not have followed S&B's advice and the advice of any independent counsel, and he gives it. Now, we're not arguing about what that is, but that is the possibility that there occurred. Girish is sitting there. He's a man who, as your lordships know, is prepared to do quite a lot, and the judge is contemplating the possibility that he doesn't follow our advice, etc. It does not follow, as night follows day in relation to that, that what then happens is that everything proceeds as previously occurred, we carry on acting and so on and so forth. And that is simply an example that within the 40%, and we would say the overwhelming likelihood is the majority of the 40%, you lead off to situations where you get to no credit being given at all. The 80% position is in the factual scenario that we have been negligent as we have been. In other words, the consequence is, as the judge finds, that Girish is still in control of the company until December of 2015, and then the administration doesn't happen, and he finds that there's an 80% chance that the administration would have been avoided and the company would have gone ahead anyway. Now, although it is correct that the multiplication of those two comes to 32%, it does not, comes to 92%, it does not follow that you are only looking as an 80%, 8% prospect of going through, because it ignores, if that is correct, all of the possibilities which are pregnant in the judge's judgment about how this could have gone off elsewhere. Now, my lords, it is right to tell your lordships that that was one of the reasons why we sought and failed to obtain permission about appealing the prospects of success, and I was going to wax, if allowed to do so, very eloquently about how all these were all absurd percentages and so on and so forth. Well, you're not hearing me on that, but what I am saying is that the logic of the position does not lead to its only 8% in the development prospect. And that's the one point I want to make by way of reply on the appeal itself.
It's tricky, isn't it? Because even on that basis, one would assume that there was some percentage chance that you would end up in the same place. But you say, well, there's no finding as to that.
Well, my lord, I effectively conceded that if one gets into the position one is in the administration position, and one doesn't, for whatever reason, go ahead. The point I didn't make to you then, however, is that it's very unlikely there's actually going to be any loss at all in that situation, because if they're going to go ahead with the amended scheme, they're going to be in the same point, etc. But that was a point I made in opening the appeal.
Yeah.
My lords, I think both my learned friend and I have just about saved within our time limits, although I think
You have.
probably owes me a drink in about 15 minutes. But I'm not going to ask for an extension of time for 7.5 minutes, unless there is anything, of course, which is still troubling the lordships, which I might be able to help with.
No, I don't detect any more. So thank you very much, Mr. Stewart. Thank you very much, all of you, for your help with this tricky case. You would be staggered if we were giving judgment today, and we are not. The reality is, I think, that you're not going to get anything before next term. At that stage, of course, you'll be provided with the judgment in draft for you to correct our typing in English, but not so as to re-argue the case. You will, I know, have well in mind the importance that is attached to complying with the confidentiality embargo. Should there be anybody extra who you think should see the judgment, then you should obviously come back to us. Again, at the stage where you have the draft judgment, we'd be grateful if you would seek to agree an order dealing with consequential matters. If there are points on which you do disagree, we would expect to address those in the order that we make. Mr. Stewart, I detect that there's an additional point to raise.
Well, there are two very short points, my lord. The first is this: your lordships, or I think probably more accurately, my lord, Lord Justice Snowden, asked for what I think he described as a guide to verdict. My lord, what I would suggest we try and do is agree that as soon as possible and put forward and agree that what we understand, just to be clear about what that is what the various permutations and calculations are, so as to avoid your lordships having to go back, look at your notes and check that you've got them right, etc. That's what we understood to be being asked for, and I'm sure if that's what's being done, we can do that on, if I can say it this way,
stating in one place what, because there are a number of things which have been agreed on interest by way of confession or otherwise, and they're not, I think, recorded in one place.
Yes.
That's essentially it. But in a sense, it will also set out what actually is still between.
Yes. Well, my lord, we certainly ought, if I can put it this way, to be well capable of producing that. And I do know from my previous experience in this case that Mr. Folkard and Mrs. Matthewson, despite the emails which occur even when they haven't got a transcript to work from, will work hard in relation to the various matters. The second matter is simply a small one. We are unsurprisingly funded in part by insurers and would ask permission to share the judgment on appropriate terms with them. Without that, we won't be able to get any instructions.
Yes, I follow. In that case, could you, I mean, it could wait, but probably preferably now, identify and send into the court specific details of those who you think should see the judgment. And then doubtless it'll be possible to agree that they should, or as you say, on the normal basis. In which case we'll leave it there. But thank you very much.